Everybody a happy Hanukkah as we are lighting candles these days, and a Merry Christmas coming up just next week. So super excited about all that. We definitely have changes, some changes that we've made to the forms, and you'll hear more about that later. Today we're talking about tenant screening, and we have a wonderful guest speaker coming on with us again. And anyway, just want to say that please always use the newest forms, download them. And right now, those forms have not been uploaded, but by the end of the week, I'm hoping that we have everything updated. But especially the rental application, qualification criteria, the lease agreement, and then the 3-day notices too. Like all those things, there's been some changes, and we've just seen the way some of the court cases have gone. We've added the date of the expiration of the notice to that. And anyway, so I know it's tricky. You're going to have to be able to count all that, but hopefully we won't get into that today. A couple things that I want to mention just as far as tools. I know a lot of you are using the AOA tenant screening. One of the things that we added to the packages, a couple of the packages is the instant. It's the bank verification. And so basically that tool, it's third party, and what it's doing for you is that you're going to get the pay stub, you're going to get the bank statements from your applicant. And then this bank verification, what it's going to do is we send an email to the applicant. They click on a link, and just like when you're applying for credit somewhere, it asks them some credit questions to verify their identity. And then they allow the program to access their bank account to pull the data and drop it into your credit report. And so when you see that from a third party, those numbers should match up. Like right now, it shows like a summary of their total income. And so that income should match, it should at least be equal to or greater than what you're seeing on their pay stubs. And so that's a way that you're verifying it. We're also going to release, I think in the next day or two, release the version that has the full detail of each one of those income entries. And so just give you more granular, just as that's been something that people are looking for. But that's instant bank verification. And it's $7, but that's just a way to just double check and make sure that what they're giving you is true and correct. And then the other thing that I wanted to mention that we've been doing for a little while, that got a question this week about it, and from a guy who owns over 100 units, and it's not his first rodeo, and he's like, hey, I ordered the deluxe package, the 360, but it seemed like it was the same as everything else. Well, that's because the criminal and investigative search is literally done by hand. It's done in person, and so that search takes anywhere from 24 hours if it's going to be a quick turnaround, and it's only during the week, during business days. So that one, however, will show you if your applicant has been litigious in the past. It will show evictions if those are there, but also what it shows that criminal reports don't show. So again, criminal reports isn't showing eviction, and it also isn't showing domestic violence. So it doesn't show fraud most of the time either. The criminal doesn't, but the civil, that's where those things are. And so we're searching not just criminal, but in the civil, and we're searching at multiple levels. And that is really, I don't know of a service like that other than going directly to a private investigator. And anyway, so it just takes a little time. And all that was instituted because of what California's been doing with the county criminal records. And they make it very, very difficult for a quick report or instant criminal report to even show you what's in there. And so thanks to Gavin Newsom for that one. Honestly, there was even a bipartisan move to get those records available to the public through the instant searches, but just he vetoed that. a while back even, and so we've had to adjust and we have to pay more. But honestly, like I think you're crazy if you don't use it to not know what you're getting into. And I know if you're listening in from Berkeley or somewhere, like I know you can't use a criminal report, but anyway, for the majority of you that still do have the freedom to do it, you gotta take the time to vet your people well. And Dennis will echo what I'm saying, I know. But anyway, so that's just a little bit of an AOA update. Also, we do want to thank Dennis P. Block and Associates. They are a sponsor of our um, 2026 Political Action Committee luncheon that's going to be held at the Marriott in Torrance. So thank you, Dennis, for supporting that generously. And we're going to have Nathan Hockman, who's a district attorney. Um, Hold on, let's see, what do we got?
You need to log in as Jeff instead of.
Is this working at all?
We can only see you. I mean, we can only hear your audio, but we can't see you.
Really? Okay, so I have to log in again. It looks like I have to log in one more time, folks. So
You have to log in as Jeff instead of the main AOE account.
okay, here, I have to log out and log back in here.
Vicky is saying that Vicky Flores is just saying that they can see you and hear you.
Yeah, for whatever reason, I think downstairs for the live stream, maybe they can't. So I'm just gonna leave and come back. But what I'll
the
do,
audience can see you, just to let you know, but maybe
right.
not on YouTube.
Yeah, maybe not on YouTube. So what I'll do, Dennis, I'm gonna hand it over to you right now and let you just go for it, and then I'll just join back in, and hopefully that will be all worked out.
Works for me, young sir.
All right. I'll be right. Go for it, man.
Hello, everybody. Yes, Dennis Block with the law firm of Dennis P. Block and Associates coming at you. For 50 years, 50 years, I have been representing income property owners in tenant eviction cases. You know, I was going to ask Jeff to start this thing off, and so he messed me up. I was going to ask him if Jeff knew the difference between a good attorney and a great attorney. And of course, we should know the answer to that, and that is a good attorney knows the law, but a great attorney knows the judge. And a lot of times in these cases that you have the proclivity of how these judges react, and it's better to know the judge than it is to know the law. The topic today is going to be getting a qualified tenant so you never have to call my firm for me to do an eviction. And if you follow everything I'm going to say today, is it possible that you could still get a bad tenant? And the answer is absolutely, because these people are very tricky. But it does require that you use diligence when you're leasing out your units. And if you do follow what's going on today, you'll have the best chance that you're going to get yourself a qualified tenant. There are so many sharks out there and thieves that are just trying any way that they can to gain entrance to your building, and that's why you have to follow procedures. I can't tell you that it is infinitely better to have a vacant unit than to have a tenant in your building that's not paying rent. By the time you finally get them out, you're going to be looking at over 6 months worth of lost income. You're going to pay attorney's fees and then the wear and tear to the unit. You're looking at $20,000, $30,000 before you blink because you chose to put this person into your unit. So it is imperative that not to take any shortcuts when leasing out your units, that you're going to go for a qualified applicant that meets your criteria. And by doing so, again, you'll have the best chance. First thing you're going to do if you're thinking of renting out a unit, even before you advertise, and this is now the law, is that you have to take pictures of what that vacant unit condition is. It is the law now, but it's actually pretty good because you have pictures of all the units. You can see exactly how it looks. And when the tenant says, no, there was no smoke detectors there, or, the cabinet doors are all ripped off. The tenants will say anything, but if you have photographic proof as to the condition of the premises before it was leased, then it cuts down not only in terms of an eviction case when the tenant claims that all these things were wrong, but also at the end of the case when you're doing deductions for the security deposit, they can't claim that that condition existed. So first thing, take pictures, pictures, video, but at the very minimum, the law does require that you do that. Uh, Most people, when they're leasing out of unit, they start off with an application to rent that they'll hand to the tenant. But I think it's better that you do some pre-screening even before an application, from that first phone call. And again, when you're renting out a unit, there's only three things you really have to be concerned about, and that is that you're going to get your rent, that the condition of the premises will not be destroyed. There will be no unusual wear and tear to your property. And also you're worried about the tranquility of the premises. Is this tenant who pays his rent and doesn't in any way hurt your property, but is he having, parties every night and everybody's miserable? So those are really the criteria which you have to consider when you're leasing out of unit and making a decision as to which applicant you're going to take. Am I going to get my rent? Is he going to take care of my property? And also, is he going to be respectful to the atmosphere of the premises so that other tenants aren't bothered? So those are the three things you always have to be considered with. And when they are calling you up and say, hey, I saw that advertisement and I'm ready to come down and take a look at it and fill out an application for you, you should start your questions right then and there. So what are those questions? Well, first of all, first question, well, why are you moving? Oh, I'm moving because I'm getting evicted from my current place. Well, if that's his response, then your question should be, well, you know what? We don't take people who are being evicted. There's no reason to come down, and there's no reason to waste your time. Then the next question you might want to ask the tenant is, how many people are planning on moving into this one-bedroom apartment? Oh, I have 8 people, my 6 children and myself and my wife. Well, gee, I'm sorry, for a one-bedroom apartment, the most I'm going to allow in is 3 people. Under fair housing rules, they say it's 2 per bedroom plus 1. And that should be your criteria. So if I have a one-bedroom, that would be 3. If I have a 2-bedroom, then that would be 5. And for a single, it's got to be at least 2. So if they answer, gee, 8 people are going to move into this one-bedroom apartment, you probably at that point say, no, you're not going to have that. Also, you're going to say, hey, do you have any pets? And they go, oh my God, I got 3 Great Danes. Well, I'm sorry, this is a no pet building, so there's no reason to come down and fill out an application. Next thing you might want to ask is, oh, by the way, do you smoke? Oh, sure, like a chimney. Well, if they say that, you can say, oh, I'm so sorry because this is a no smoking building. Nowhere on the premises can people smoke. Then you might want to ask them, hey, have you ever been evicted before? If they answer in the affirmative, again, there's no reason to fill out an application because I'm never going to accept a tenant who's ever been evicted in his history. So if he admits that he's been evicted, you don't have to do that. And then you might ask him, well, how's your credit? Because we only accept people with a credit rating of 700. I think that's the new criteria now. And I'll go into why I think you should have a higher criteria now based on doing credit checks. And also, you're going to tell the tenant, hey, I'm going to require all the money in advance before you move in. So that would be the first month's rent and probably a 1-month security deposit. And I'm going to need that. Well, you mean I have to have that all to move in? Well, of course. He said, well, can't I make the payments on the security deposits in, half installments? If the tenant says that to you, he's telling you he doesn't even have enough money to pay a security deposit and a first month's rent. Well, that's not a tenant that you want, and say, no, I demand that you'd have that. So if you're not going to be able to pay me that, then quite frankly, you're not getting into my building. Also, you want to tell the tenant, and this is such a good position to take, and that is, oh, by the way, I'm going to demand that you show me proof of payment to your current landlord for the last 6 months. I'm going to ask you to show me that, either withdrawals from your bank account or copies of money orders. I need to see that for the last 6 months. That's going to weed out a lot of people who already are in the process of being evicted, or who is just their current landlord is so thrilled for them to go because they weren't paying rent and they were trying to coach them to leave. So you're going to tell the tenant right on the phone, by the way, as part of the criteria, I'm going to need you to bring, of course, proof that you had 6 months payment to your current landlord. So these are the initial questions that you need to ask your tenant right while they're on the phone. Now, when they do come down to you, then you want to first hand them what they call the leasing criteria. I'm going to show you the AOA form, which of course is excellent. And this is the criteria for renting your units. Technically, under California law, you cannot charge a credit fee unless you give them a copy of this criteria. You might want to photocopy this onto the back of the application. So, because otherwise you're going to ask them to sign this criteria. And this is actually, it is the law now that you cannot take an application charge, a credit check fee, unless you have handed them this, which they're going to need to sign for you. And I really think this is a good idea because this will cut down on discrimination cases. So if they're going to claim, oh, you didn't rent the unit to me for discriminatory reasons, you can say, look, this was my criteria. I handed it to you when you came down to fill out the application, and you didn't meet this criteria. So that's the reason why you're not getting the into my unit. So as you can see here, as we go down, you would fill in a credit score. I'm going to do that now. So that would be like 700. You want to show the fact that they must earn at least 3 times the monthly income, that they have no prior unlawful detainers. So these are the criteria that you're going to use. You're also going to
Hey, Dennis, on that criteria about 3 times the rent,
Mhm.
would you do that for any class property in any location, or is that more like just a standard for standard type of building?
I would probably do it on any place. However, I was going to go into some exceptions dealing with Section 8, but I think 3 times the monthly rent is reasonable. I mean, here's the problem with this is that if your tenant's car breaks down and it's $1,000 repair and they don't have any wherewithal, then the problem is going to be then they're going to fix their car and you're not going to get your rent. So I think it should be at
Absolutely.
least 3 times the monthly rent on that. And
Right.
again, you're going to need to have a photo ID, like a driver's license. And of course, the tenant can say, well, gee, I don't want to show you my driver's license. I don't have to. Well, this is my leasing criteria. And if you don't want to show me your driver's license, you certainly don't have to. But on the other side, you're not getting into my building. So I would go through this. You also want to tell them that I'm going to need you to require renter's insurance. And I want to see a copy that you actually purchased that and have that as part of the criteria for moving into my building. Okay. You also, of course, want to tell them that in this rental criteria that they have to have proof of income. I want to see what you're making, and I need to see proof of that. And of course, I think the application fee, you have to tell them what the application fee is on that. But again, this is the leasing criteria. It is required for you to take an application fee. I think I wrote down what the maximum application fee is. It's $64.50, unless you're going to correct me, Jeff. I just looked that up. That's the maximum that you can take, or whatever it actually costs you to do that.
Did you say 66 or what did you say? I
I
missed
said
it.
$64.50 when I looked it up today.
Yeah, I thought it was 66, but yeah, every year it goes up based on CPI. So yeah, it's going to be in there somewhere between 66 and 64, $66, somewhere in there.
Okay, so again, this form, which is on the AOA website, and again, one of the wonderful reasons for joining the association is called Qualification Criteria for Renting. This protects you. Okay, it also allows you to take a credit check fee, but this protects you from these cases of discrimination. And technically, under the law now, it's the first applicant that meets these criteria you do have to rent to. And technically you can only run one application credit check at a time. If you run two at the same time, then you got to give the credit check back to the second tenant, even if the second tenant had poor credit.
Yeah,
Okay,
and hold on with that one. I think there's a lot of confusion. So that's the straight way. There is the one other option that we probably should mention is that if you don't take any application fee at all, then you would have the ability to pick and choose. Like you could run multiple people and pick the best one, but not if you're going to take the application fee. Is that, am I think
you're
I'm,
100% correct, Jeff.
yeah, okay.
If you don't take the credit check fee, then you are allowed to build up your applications and take the most qualified one. However, again, we still have that exception dealing with Section 8, which I will get into. Okay. So again, you want to be sure that the tenant is made to know that we're going to need good references. We're going to need to know that there have been no bankruptcies or prior eviction or collection cases. You also want to make sure that there is no criminal background. However, under the HUD guidelines, you have to take into account what the conviction was, what the criminal conviction was, and when it occurred. And it has to have some relation to your building. So, for example, if the guy got a DUI 20 years ago, I don't think that would be grounds to reject him just on that criminal conviction that he received. Here's some questions that you can't ask your tenant, and that is, have you ever been arrested? You can't ask that question because it's not relevant. It's only if they've been convicted. So you can ask them if they've been convicted of a felony, but you can't ask them if they've been arrested. You can't ask tenants their age. That's a sure-fangled discrimination lawsuit. You can't ask questions regarding race, nationality, or religion. You can't ask questions regarding their disability or sexual orientation. Or, hey, are you planning on having children? That's a question you can't ask. However, the landlord is free to set whatever conditions he wants for a tenancy as long as they're reasonably related to his business needs and don't violate any anti-discrimination policies. Like how many people will be coming into the unit, who will occupy the unit, and where is your source of income? You can't discriminate on the source of income. So if he tells you or she tells you that it's an alimony, well, you can't discriminate in that as long as you can prove that it is being done. Okay, so you've handed them the rental criteria. You had them sign it and kept a copy. And then the next thing you want to do is you want to give them an application. Let's move on to that. I should have pulled this out here. Bear with me. Let's get to the application. I won't have that up as long as I did before. Okay, here is the AOA application. Again, it's an excellent form. You're going to have them fill out this form. Again, you can get this from the AOA website if you are a member. And it lists everything from employment, their residence, their vehicles, personal references, credit histories, and a whole bunch of questions that they have to answer to. And these questions are really important because let's see, what did I do here? Stop sharing. There I go. These questions are really important because in your rental agreement, you should have a phrase in your rental agreement that states that any misrepresentations on your application will be considered grounds to evict. So if the tenant on his application states, I've never been evicted before, and you find out that the tenant has been evicted before, that would be a great ground to evict. I know I had a case a few years ago, which I've talked about before, that the a tenant moved into a house in Malibu, and my clients who lived in Salt Lake City thought she was very nice, and all of a sudden she's paying the rent, but she starts filing small claims court lawsuits and making demands for her to do everything and anything possible. So the client came to me and said, "Is there any way we can get rid of this person?" They were on a lease, and I figured with this type of a history for this person that they'd probably been evicted before. And again, we did find out that she was evicted before, and that was the grounds that we used to start an immediate eviction case because she lied on her application. So you want to make sure that they fill out this application in full and make sure that every adult who's moving into that specific unit must fill out an application. You don't want to have the person, of course, with the good credit fill it out and the guy in the background who doesn't. So everybody who's going to move in, who's an adult, must fill out the application separately. And of course, you have to run a credit check on that. Again, these criteria that's contained in this application needs to be filled out completely. If they leave blanks and they don't fill this out, then that's a reason for you not to rent to them because I have an incomplete application. So you want to see their driver's license number, their social security number, their bank account numbers, okay? I'm not a big fan on these types of leases to ever do what they call a co-signer or a guarantor under the lease. In a general situation, if the person who doesn't have sufficient credit to move into your unit, then I would pass on them because to chase after a guarantor who might live in Idaho or some other location, it's not going to be an easy procedure. In addition, if you do file an eviction, you can't file an eviction against a guarantor because the guarantor is not unlawfully detaining the premises, which means you'd have to first do the eviction and then you'd have to file a separate lawsuit against the guarantor. So generally speaking, unless there's some special circumstances like you have housing by USC and these are just students, for example, then you generally want to avoid guarantors under that. So again, once you've handed them that leasing criteria, then you're going to have them fill out this application in full, making sure that that there are no inconsistencies or no missing spaces. Now, it's not enough that you just merely get a completed application. You have to do something with that application. And that is you want to check the sources. You want to check their employer to make sure that they're really working there. And please don't rely upon the phone number that they put on their application of their employer. You want to do a Google search to check to see exactly what their real phone number is for that employer because they might put down another number and there's somebody waiting, in the background to say, oh my God, the guy's been here for 20 years, and makes $95,000 a year. So you want to use your own search criteria to call that employer and to make sure that the person is working there. And again, go through their references. It's not just enough to take them. Go through their references to make sure that that you're getting good information on them. You also want to check social media, check Facebook, check Instagram, and see how they're listed there. If you see that that the guy is having toga parties or is a big social advocate for having big get-togethers, well, maybe that's going to tell you that the person is not qualified. Or maybe you're going to find out by checking these that they've had problems at their other places. So you do want to check social media, run their checks on that. You also want to check for civil lawsuits. We'll get into that when we run the credit checks. But again, if you find out that this person has been the subject of 15 lawsuits where he's sued 15 people, including his 3 prior landlords, you know what? This is not the guy that you wanted your property. Some of the questions that you could ask on that application is, Has anybody ever asked you to move? Has the landlord ever asked you to move? See, these are invaluable that if you find out that the previous landlord did, well, then that would be a misrepresentation on the application and it would give rise to have this tenant to be evicted if he did get into your building. Okay, after we've gone through handing them that renter's criteria, we had them fill out that application and there was no blanks, and we had every adult fill out that application and you've actually checked it out independently. Well, the next thing you want to do is you want to call up the AOA and you want to have a credit check. And Jeff, this is your time that I want you to shine by telling the audience exactly what's about your credit check. What do you guys do for us when we say go do it?
Right. Yeah, and before you run the credit check, also there's Form 100D. We've had a couple questions in the chat there about it, but Form 100D, what there's a California Consumer Protection uh, declaration basically, and there's a little checkbox where if they check it off, you have to give them the report within 3 days. Then there's also federal, the FCRA, Fair Credit Reporting Act, and both of these things need to be disclosed to the applicant if you are going to run a credit or background check on them. And so you give that to them up front, they sign that, then you run the credit, or you have them run their own credit somewhere and share the report through a third party. So you go through that process, and then yeah, like as far as what we have to offer, we can do a credit report for $8.50, and you're not going to find it cheaper anywhere else. And next year the price, it's going to stay the same for what we call the tenant risk score, and this is a new credit score or newer credit score, and it is weighted based on their consumer behavior tied to housing. And people with thinner credit files, it's able to give them a score where the traditional FICO would not. Supposedly it's 15% more predictive of whether they're going to pay the rent or not versus the FICO. This is available in the, when you run a credit report, you can pick a package, but then you also have the option to pick the FICO or pick the tenant risk or resident score. So you have those options, and the FICO, these guys keep jacking the price up. So we're actually going to have to raise the price on the FICO, but keep the price on the other exactly the same. So that's just credit reports. And then with the other one that I want to mention for sure is just the fact that we have the clean slate law here in California, which what it's done basically at the county level, many of the counties have removed certain personal identifying information from the top of the file. And it's a little bit more difficult for software to really identify positively that this John Doe is the John Doe, your applicant, and yeah, he does have a criminal history. And so what tenant screening companies are doing, super sophisticated, they're using arrest data. They're not reporting arrest data, but they're using that as pointer data, and then they back into the file, into the criminal file, and then they're able to show something. The only problem is that not all the arrest data is available, number one, and then also the fact that not every conviction also included an arrest. And so it's not a comprehensive or a complete set of information, where what we're doing with the civil and criminal investigative search is we're literally, there's a private investigative firm that is handling the whole file in person. And so they're searching on the criminal, and then they're also searching again on the civil, and the civil isn't just showing you evictions, it's going to show you all kinds of judgments that may be against them. It's going to show litigiousness. It's going to also show domestic violence. And so there's something called the duty of care doctrine that puts the responsibility on you to keep your renters safe. And you already have a financial motivation to keep them safe and happy. But there's also like a legal implication too, and so that's why we are recommending that people do the civil and criminal investigative search. That's what we call it. And basically, we run a skip trace, so immediately you know, does this social belong to this person or not? And then you get a full list. You get that immediately. But then the investigative firm, they take that list and they're running the searches based on everywhere that they have lived. And so that's just another one. Again, it doesn't come back immediately. It takes a little time because these are real people that are doing real work, and they're doing stuff that computers just cannot do at this point. So anyway, so those are a couple things that are kind of unique to AOA, and not everybody who screens with AOA are using those tools. That instant bank verification, the bank verification stuff we talked about, I talked about on the front end too. It's just worth it to really vet your people well because it's so hard to get them out. You don't want to have to call Dennis.
No, no one ever wants to call me. By the way, a very important fact, and it's under California law now, is once you get that credit report, you got 7 days to give it to the applicant. So I would immediately forward that to them. I'm noticing that some people are in the chat room are asking some questions. By the way, at the end, we are going to open this up to questions and answers. If you're in the Zoom meeting, if you electronically raise your hand, you can do that right now. We'll call on you. Also, if you're in watching this on YouTube Live, you can leave it in the comments there, and we'll get to that. Some of the questions are saying, well, what do I have to tell the tenant if I'm rejecting them? Well, if you're rejecting it on whole or in part by the credit report, then you just have to state it's because of your credit report, and you give them a credit report, and then it's their job to figure that out. Also, if it's not on the credit report, let's pretend it was on something on social media. There's no obligation to say it, but in order to cut down on potential lawsuits, say, look, we looked you up and we found this about you that the last landlord had complaints about you making too much noise in the unit. So you don't just evict a person, or excuse me, reject a person based on their credit history. There's all sorts of things that can go in legitimately that landlords can reject an applicant, even though he might have a great credit score. Okay. I mean, if the guy sat there and always blocked his car, for example, so other residents couldn't get into their parking spots. That's a reason to say, you know what, you're just not a good human being, and we got a bad report from your previous landlord. So should you tell him that? I think you should tell him. I don't think there's any obligation to tell him, but in order to cut down on potential lawsuits, I would state this is the reasons why. It was based on your references that you supplied, and I talked to your previous landlord, and on that basis, we did think that you would be a good fit in my building. So, again, though, you have an obligation within 7 days to give them that credit report. So as soon as you get it, just forward it over to the applicant. Every applicant, you must forward that over to them. What are their reasons to reject an applicant? Obviously, based on income, or you can't verify their employment, or maybe that they have a good job, but they've been on that job for 2 weeks. If they haven't really have a long history of employment, that would be a legitimate reason not to evict. They're in their quote probationary period. They might not even last past a month. Also, you can reject on their credit history. Again, if they have bad credit, or if they have pets or smoking, or again, if you found out before they got into the unit that they had an incomplete application or that they lied on their application, that's the best reason right there. I'm sorry you're not getting into my building because there's misrepresentations on your application. And obviously, unsatisfactory references from their landlords, their employers, or for personal references. Now, let's talk about Section 8. You want to get sued? So simple. When they call you up and say, hey, do you take a Section 8 voucher? And you say no, now you're going to get sued. And there's these spotters that are calling up landlords and asking them whether they take Section 8 vouchers. Your response is yes, we love Section 8, okay? Because if you say anything to the contrary, you're going to get sued. So in the past, I would always tell my clients, take a Section 8 because you have to, but then run their credit check and they're not going to meet your criteria of 700. So on that basis, you're going to be able to clearly and easily reject them. At least you think you can, because on January 1st of 2024, they changed the law. You cannot reject, this is insane, absolutely insane. You cannot reject a Section 8 applicant for bad credit. Who could make a law like that? Well, I can tell you, it's the California State Legislature and signed by our wonderful governor. They say you can't reject, anybody, you're loaning money, getting a car loan, anything, you run your credit. Well, not if you're Section 8. You go on something called the ability to pay. So we all know that under Section 8, it's a rent subsidy, and if the rent is like 2,200, for example, Section 8 is going to pay 2,000, and the tenant's share is only going to be 200. Well, if the tenant can demonstrate his ability to pay $200 a month, then you have to accept that. So again, Section 8 is a whole nother criteria. They really want people to take Section 8 tenants. So again, if you're asked the question, of course you do. And then you can't reject them on the basis of credit now, since that law came into effect back in January of 2024. I have heard, and I've stated this before, that Section 8 will not accept rental agreements that are less than 1 year. So I recommend, and I recommend this for a multitude of reasons, that just do month-to-month tenancies from now on. If you're under statewide rent control, you don't need cause to evict if the tenant's been there less than 1 year. If you're under the just cause ordinance for the city of Los Angeles, you don't need cause to evict if they've been there less than 6 months. So on that basis, and also on the basis that I doubt Section 8 would accept that, then your criteria should just be do month to month. That's what I'm recommending to everybody. And if you don't want a Section 8 tenant, then it's up to Section 8 to say that they're going to want that type of agreement. Let's move on to a new one. And that is the last thing we're going to do here is we're going to have them sign a rental agreement. And this is the AOA rental agreement. I helped co-author that. And it is probably one of the best rental agreements on the planet. So you're going to download this rental agreement. And remember, every adult who's moving into your unit must sign that rental agreement. Every adult who's moving into your unit must sign the rental agreement. So if they say, oh, my roommate's, on a business trip and they're in Colorado, your position is, well, I guess you're not moving in, okay? So let's stop sharing there. So your rental agreement, and this is an excellent one and contains all of the things I'm about to say, should state that there's a no smoking policy in the building. Even if you smoke like a fiend yourself, you don't want to have any smokers in your building because some other tenant's going to get upset and they're going to complain that they're getting cancer because they walk by somebody with a cigarette in their hand. So you want to make sure that there's no smoking anywhere on the premises, not just in their own unit, but anywhere on the premises in any common areas. So make sure that your rental agreement states that. You also want to make sure that your rental agreement has a phrase in it that states repair requests, except for emergencies, must be in writing. That repair requests, except for emergencies, must be in writing to the landlord, either by email or by text or by, actual physical letter. And the reason for that is because when you do go forward with these evictions, the tenant is always going to claim, well, I didn't pay the rent because the premises were uninhabitable and I asked the landlord to fix it and he callously refused. Well, you need to have this phrase in your rental agreement because then you can throw it right back at the tenant saying, look, you never told me, but if you had told me, you were supposed to do it in writing. So where's your writing? So this way it will look like the tenant is just, of course, making things up. So that's a very important provision to have in your rental agreement. You also want to have a provision in your rental agreement that the tenant must carry personal property insurance, and you want to see proof that he purchased that insurance before allowing him to move in. Now, the reason why you want to have personal property insurance by your tenant is because you want to make sure that your tenant can't sue you. So if through no fault of the tenant, if there's a flood in the unit and all of his wonderful personal property is destroyed, he's going to look to you for compensation because after all, it wasn't his fault that the pipe broke. But you see, by forcing them to have personal property insurance, this way it's going to state that, hey, you could only look towards your own insurance company for compensation and you can't go after me, even though it wasn't your fault that that pipe broke. The other thing that you want to make sure that it states is personal property insurance that not only covers the tenant's personal property, but this renter's insurance policy will also cover the renters if they have to temporarily relocate. So if there's an issue that cropped up in the building, like you had to tent the building for termites, or again, you had to make that major repair because of the damage, you want to make sure that the requirement was that he had to have renter's insurance, which also covered my temporary displacement from the premises. This way, he can't be extending his hand out to you and saying, hey, where's my money to purchase 3 nights at the Ritz-Carlton or possibly the Four Seasons. So you want to make sure that that's part of the requirement that they have renter's insurance that covers any damage to their personal property and any relocation expense. Now, the proof is that if they are in personal property or renter's insurance lapses, can you evict them because that's a term of your rental agreement? And unfortunately, under California law, that's not considered a substantial uh, uh, breach of that rental agreement. So on that basis, you can't file an eviction for failure to have renter's insurance. But again, you don't really care about him having it or not. What you care about is that you will not be liable for his personal property or for his temporary relocation expenses because that should have been covered by his personal or his renter's insurance policy. So whether he had it or he didn't have it, then he can't come after you. So that's the reason why you want that there. You also want to put a limitation on attorney's fees in your contract. I know the AOA has that where it's limited to $500. So if you're going forward with an eviction case and God forbid you lose on a technicality, the other side is going to ask for attorney's fees of, $20,000. Well, you want to make sure that you always have an attorney fee limitation. Again, if you won the case, you could ask for 20,000, but again, it's difficult to collect against these tenants. But quite frankly, my friends, it's not difficult to collect against you. So you want to make sure that in your rental agreement that you have an attorney fee limitation. If it says in your rental agreement that reasonable attorney's fees, that's bad because that means that they could get up to $20,000. You also want to have a phrase in your rental agreement that states that for any personal injury sustained by the tenant that they have to go through arbitration. This cuts down a lot of spurious lawsuits and makes it much more easy for you to defend yourself and less costly. So make sure that there's an arbitration clause just for personal injury, not, of course, for unlawful detainers, which would be much more cost effective to do a regular unlawful detainer than it is to do an arbitration. You want to make sure that in the rental agreement, again, the AOA form, that all the tenants' names are there and they sign that, but you also want to list all the occupants' names. So that would be all of their children, anybody under the age of 18. You want to have the names of those children and maybe their birth dates so that they can't shuffling in different people. So everybody's listed on that rental agreement. You want to make sure that you have a parking clause in that agreement, where they're supposed to park, assuming you're issuing parking, what space, how they can't park in the common driveways, and they can't park on the front lawn. You want to make sure that they have a specific space designated in that rental agreement, because this way, when they're parking someplace else, then you have the ground to evict. So if it says you get one space, but you don't designate where it is, they're going to park anywhere, and that's just going to be a hassle for other residents. So make sure that you designate where they're supposed to be parking. Um, Also, you want to make sure that if your property is not subject to a local jurisdiction, and this is very important, that you mark whether the premises are subject to statewide rent control or not. So, for example, let's pretend you have a single family home in a beautiful city where my office is in Burbank, and you're leasing that home. You want to make sure that you check the box on the AOA form that says this property is not subject to statewide rent control, because single family homes, townhouses, and condominiums, and also properties built within the last 15 years are not subject to statewide rent control. But for single family homes, condos, and townhouses, you actually have to check the box that says this premise is exempt from statewide rent control. So why do I say that? Why is that important? And the reason for that is that, let's pretend the guy's been there for a few years. He moved in, let's say, 2022, and you didn't check the box for this single family home in Burbank. And let's pretend you come to the conclusion that you want to leave the state of California. A pretty good idea at this point in time. So of course, you want to sell the house. And you can't sell the house with a tenant in possession. You have to get the tenant out. You have to clean it up. You have to stage it, correct? So you need the tenant to move. So of course, he's on a month-to-month tenancy, right? And you're in Burbank. There's no local rent control. But unfortunately, you didn't check that box that says this is exempt from statewide rent control. So by not checking that box, you have to have a reason to evict. Well, I have a great reason to evict. The reason I'm evicting is because I'm going to sell the property and I need you to move. Unfortunately, that's not a reason to evict under statewide rent control, which means you're kind of stuck with that tenant and it's going to tremendously interfere with the selling of the property and probably making you get a much less price because you have to sell it with a tenant in possession. So if your property is not subject to a local rent control, then you want to make sure that you check the box that it is either subject to statewide rent control or, more importantly, that it is exempt from statewide rent control. Very, very important. Also, under statewide rent control, you would think that you could have a family member move in. So you know what? My son is now turning the age of 21, and I've got this apartment house that's not in Burbank, so it's not subject to a local rent control, but we know it's subject to statewide rent control, and I want my son to move into one of those units. I don't care which one, and I don't mind paying relocation. Well, you can't do it. What are you talking about? You can't do it. You can't do it unless there's a phrase in your rental agreement that says your tenancy may be terminated for an owner or a family member move-in. You don't have that exact language in your rental agreement, which of course is contained in the AOA rental agreement, then you can ask that tenant to move, and your son is going to continue to live with you until probably he's about 62 years of age, okay? So make sure that that phrase is in your rental agreement. And all these things I'm talking about are really simple. Just get the AOA rental agreement, and then you're covered on all these important issues, these issues that are so important to have contained in your rental agreement. Now, you went through all this stuff with the initial questions. You gave them the renter's criteria. You had them fill out the application. You did the credit check. Now you're at the point where you're giving them this wonderful rental agreement to sign. One thing is certain, you don't sign it. You do not sign this rental agreement, Mr. or Mrs. Landlord. You must have the tenant sign it first. Once they sign it, then you sign it, then you give them a copy of that rental agreement. Because if they have your signature on a rental agreement, they're going to run away. They're not going to come back. You're going to have to rent it to somebody else, and then they'll come back and they have your signature. So never sign the rental agreement first. Every adult who's moving into that unit signs it. Then you're the last person to sign it. Now, one more important thing. You've gone through all the things I'm talking to you about, and you know you're going to collect a security deposit, which in most cases is only 1 month's rent now based on the silly law. The exception would be if you have a total of 4 units consisting in 2 properties, then you can get a 2 month security. But you're going to get that security, you're going to get that first month's rent, and you're going to make sure that the guy gives you a cashier's check. No, you're not accepting anything like that. You can accept a personal check, you can accept cash, you can accept a cashier's check, but they're not gaining entrance to your property until the funds have cleared. They must clear your bank account. People are creating counterfeit cashier's check. Do you know what a Chase cashier's check looks like? Or a Bank America cashier's check looks like? Well, these people are creating these things. They give you the cashier's check. You think the money is certified. It's not. So I used to say cash or cashier's check only. Now I've changed it. I don't care what you take. The funds have to clear your bank account prior to allowing them possession of the premises. Now, the last thing, and the last thing is the last thing you do when you rent out property. Do you know what that is, Jeff? You got to unmute yourself. What's the last thing you do when you rent out property, Jeff?
After you've done the walkthrough and taken the pictures and all that, and you've
Yep.
received the money and everything's in place and you have the lease and everything,
Yes. What's the last thing you do?
give them the keys.
Give him the keys. You got that right. I think you've heard this lecture before. Yeah, the last thing you do is you give the key. Just hang on to that key with all your strength, okay? Because you got to go through all those other issues first. And if you do what I'm saying, I can't guarantee you that you're never going to get a bad tenant because situation changes with tenants sometimes down the line. But at least you'll have the best chance of having a tenant that you're not going to have to call that pesky number 1-800-77-EVICT, ladies and gentlemen. So now we're going to open it up to questions and answers. I see that we have
Yeah,
Kerry
let's
Davis. Should we?
definitely do the
Yeah, let's do him first. I just
hand
unmuted you,
raise
Kerry. So
stuff
unmute
first. Yeah.
yourself.
Hi
What's
there.
that?
Hi there. Thank you for what a fantastic webinar. I have a question that also was in the chat, which is, do you need to give a reason for not accepting an applicant? I know you went through all the reasons to give or things to not say, but do you need to even give a reason, or can you just say, we found another applicant that was more suitable?
Well, first of all, if it was partly or wholly based on the credit report, then technically you do have to tell them the reason that it was based on the credit report, but they already have a copy of that, but you'd have to state that. As to the other, if you haven't taken an application fee, then you could say there was a better qualified applicant than you. That would be fine. However, if you have taken application fees, then technically it's the first one. So you're going to need, in my opinion, to say something to them to justify why they're not being selected.
Thank you.
All right,
Great.
and
Any other questions here? Like raise your hand and we'd love to just take your question live. And I know there's questions in the chat and there's questions on YouTube, but just raise your hand if you're in the chat
yeah, there's a
meeting
button on
room.
the bottom that says raise hand if you're in the Zoom meeting room. Oh, I see Amy
There we
Bennett.
go.
I'm going to ask you to unmute yourself. Amy?
Yes, I have a question about when you hand the keys over. Because let's say your renter comes in and the rental agreement says February 1st. Do you give them the keys at 6 a.m. February 1st, or can you give them the keys the day before?
Well, I mean, technically, if they're supposed to, if it says that it's starting February 1st, that would be midnight. So I'd give it to them, the day before. However, again, you're not going to give it to them unless everything checks out first and all the funds have cleared.
Thank you so
Great.
much.
Okay,
Thanks,
thank you.
Amy. All right, we got
Moving on to
John there.
Juan Juarez. I'm going to ask you to unmute yourself. You have to hit the unmute button, my friend.
There we go.
There we go. Sorry about that. A little fuzzy on the 3 times monthly rental on the income portion. is that combined household income or is it individual?
It would be combined household income.
Thank you.
All right,
Great
good
question.
question. Let's talk to, it says here, work. I'm going to ask you to unmute yourself.
Hi, this is Talia. For the for the qualification criteria, how many negatives on the consumer report do you recommend is okay to have?
I'd have to have more information as what those negative things were.
So, but you know how there's like negative, positive, because that we can fill in the blank on the AOA form.
So that would be, Dennis, it would be like there was one account that they didn't pay, like they had one credit card debt that was bad, and so they didn't pay that one.
Well, again, I think it would have to go on the credit score. I'm sure that would bring down the credit score. So I think if it meets your credit score rating, I think you'd be okay if there's only one bad debt.
Yeah, Talia, I know what I hear your question, and it's hard to put like I can't give you an exact number. I know where your properties are and everything. So I think you could probably allow a couple, but yeah, like Dennis is saying, it will impact the credit score a little. But
Like for
yeah,
a credit score of 700 is really high
right,
for
I know
some of these areas.
for your properties, you would go a little lower. I think you're at what, 680 or 650?
We put it at 600 and
Well, it all
make it at
depends
all.
where your property is. You know, if you're in South Central LA versus if you're renting out, a $4,000 unit in Beverly Hills.
And that's the difference here. Yeah, with where her properties are.
So what do
Yeah.
you recommend for like the 1920s buildings in Koreatown type of those places that people don't have even a 600?
Here's my position, and I didn't get to talk about this, but under an insane California law, if you don't have a judgment against the tenant who's being evicted within the first 60 days, then the eviction record is sealed. So even though you're going to run a wonderful credit check with Jeff's AOA, the problem is you can't really tell if the guy's been evicted before. So I like to err on the basis that, of course, it is also an economic issue, but I like to err on the basis that I want a higher score because I can't tell whether this person's been evicted before.
And I think another way, like working with that, like she's having a hard time finding people with 600, with higher than a 600. It's getting hard to rent. Look at lighting, look at the like curb appeal, lighting, security, like those things to make it pop a little bit more. Like there might be some simple upgrades that could be done that might help attract people with slightly higher scores. And I don't know like what you guys have done or where, the condition of every building or anything, but that might be something that helps with that one. But we do want to just take one question per person. So Talia, thank you so much for that one. And it looks like we
Let's
have
move on to Vicky
Vicky.
Flores.
Yeah,
Ask you
please
to unmute
unmute.
yourself.
There we go.
Hey there. So I've used recently the real estate broker, the rental agreement, and I thought it was pretty good, but it sounds like the AOA is better for the rental agreement. What do you think, Dennis?
I'm in favor of, the CAR forms, California Association of Realtors,
Yes.
is an excellent rental agreement. I really don't have any problem with that agreement. But I think the AOA agreement is more defensive in terms of that if we need to evict a tenant, there's a lot more in there that will give us some bang for the buck on that. So I'm a big fan of the AOA rental agreement.
So with
Right.
that, so the second part was, since I'm on older agreements, can I change them? Can I ask my tenant to sign a new rental agreement?
Well, you can ask a tenant to sign anything, but the issue is the tenant legally has no obligation to do so.
So I
But
could
again,
ask
if you're
them.
using the CAR form, you're not far off, okay?
Okay.
Right.
Actually, you've used one, and it got me out. So you've actually helped me.
Oh,
So,
thank you.
and it was a car form. Thank you.
Yeah.
All right, Vicky, moving on to Sarah Chang. I'm going to ask you to unmute yourself.
Hello, yes, my tenant's rent included the parking fee, but because the HOA has increased the parking fee this year, I mean for 2026, I need to charge the tenant extra to cover the parking fee. Will this
Well,
be, will this be considered a rent increase that the renter can dispute, or is it okay to charge this as a separate fee?
good question. Is this in a condo or a townhouse?
Yes, it's a townhouse.
Well, I'm happy to tell you that there are no rent limitations for a townhouse. So if in fact the tenant is on a month-to-month tenancy, you can
Yes.
raise the rent to whatever you like. So
Okay.
raise it as much as you like. You don't even have to keep it in accordance with how the parking fees went up.
And
Okay?
if she complains and wants to
You can
move,
yeah, well, then let her move. The bottom line is you have the right to raise the rent to any level because it's a townhouse, condominium, or a single family residence.
Sarah,
okay.
are you in LA County?
No, in Orange County.
Oh, okay. You're in the land of the free even.
No, actually, Orange County is starting to have some problems too. Santa
Yeah.
Ana, and I
Santa
just
Ana is
found out
different.
that Buena Park started rent control. Oh my
Yeah,
God, it's
true,
crazy.
true. Okay. All right. Thank
Anyway,
you,
thank you,
Sarah.
Sarah. We're moving on to Amber. Amber, ask you to unmute yourself.
Hi, thanks for taking my call. So, I have a sort of a unique situation. I inherited a bunch of properties, unfortunately, because my dad passed away recently, and I don't want to do this. But um, we normally go with three times the rent as a qualifier for renting to tenants. And we recently had pushback on a rent increase because the tenant's argument was that if I have to make three times the rent in order to live here, by you raising the rent X amount, I no longer make three times the rent. So by that, I technically don't meet your qualification criteria, and they want either for me not to raise the rent or out of their lease. And so I'm not sure how to handle this.
Well, first of all, you can't raise the rent if they're on a fixed term lease.
It's
So,
expiring. So we're going to
so,
raise
it,
the rent. Yeah.
so if they want out of their lease and it's expiring, all they got to do is give a 30-day notice having nothing to do with your rent increase. But the issue that your tenant raising is totally fallacious because that was my criteria for you moving in. That's it. After that, it's the wild, wild west. I can raise the rent as much as I want. So you can't use that as a reason why I can't raise the rent. That was only the criteria upon gaining entrance to my building. You are now in my building, and therefore I can legally raise the rent to whatever amount I want to.
It may
Okay.
be a good negotiation tactic that they're using with you there too, Amber.
Gotcha.
They may be just good negotiators.
Is
And
this your number on the screen? I think I've gotten some conflicting information in reference to the property, and so I probably need to call and talk to you, Mr. Block, because
Yeah, it's 1-800-77
okay,
evict. That's
perfect.
it.
Thank you.
And
all
thank
right.
you. Well, I
Hey,
see
I
we
know
got through.
we're kind of past time there, Dennis. Usually you only go to 11 o'clock and you gave us an extra 10 minutes.
Hey, you know what? Only for you, Jeff. What can I say? We have our big holiday party for the office today.
Oh man,
Yeah,
I didn't get
so
an invite. What's up, bro?
I said for the office today.
Oh,
So
okay, I get
taking
it.
taking everybody out. So
Oh,
anyway,
cool.
Jeff, happy holidays to you. Happy holidays to all the members who tuned into this broadcast. And Jeff, as always, thank you very much. You guys might know that every Saturday at 3 p.m. live, otherwise you can watch it on YouTube. I do a Zoom/live YouTube meeting. And that's every Saturday at 3 p.m. if you want to watch it live. And if you want to, like you're doing now, be in the Zoom meeting and I call on you after the opening topic. And to get to that meeting, just go to my website, which is evict123.com.
All right. Hey, everybody, again, thank you. I know we couldn't get to all the questions, and yeah, so we'll just have to do it again. So give us a call, give Dennis a call if you have any questions, and we're here to serve you. We updated our phones massively. So if you've had trouble getting through in the past, try again. I think we've really been able to enhance that. And yeah, thanks again. Happy Hanukkah, Merry Christmas to everybody. And it's time to look at those goals and get it set up for next year. Take care. Bye-bye.